Kasprzak, and he's running for the 457th Judicial Court judge position. It's Wednesday, November 6th, 2019. With me is Larry Rogers, Dale Fessenden, James Byers, Bob Bagley, Dennis Tibbs, and Pat Tibbs. So Robert, as we discussed, thanks for coming in.
Thank you.
And you're welcome to take up to 5 minutes on opening, and then we'll proceed with questions.
Yes, sir. Well, thank you. Thank you all for having me tonight as well. I guess I'd like to start by explaining why I'm the right fit for this particular court. And as I think you probably already know, and we'll probably get into it in the questions, this court will hear civil cases. I'm a civil lawyer. I've been a civil lawyer my entire career. Even before my career, I clerked for a civil lawyer when I was in law school. So I've been practicing law for 15 years. All 15 of it has been in civil law, and 2 years before that, clerking for another civil lawyer. While I was waiting in the lobby for you guys, I jotted down some of the areas of civil law that I've acted in. Usually it's easier to explain civil law by explaining what it's not, because it's easier to, there's very few things that it's not, and which means that there's a lot of things that it is. So I've done evictions, car accidents, insurance claims, business litigation, contracts, products liability, fraud, collections, judgment enforcement, securities, construction defect, wrongful death, county and city development, trespass, sales, shareholder derivative suits, land disputes. And this is outside of my career as a general counsel to several emerging and developing stage companies. And in that area, I've done corporate governance, transactions and contracts, business management, corporate oversight, dispute resolution, business development, securities and investments, mergers and acquisitions, corporate strategy, human resources, research, litigation, compliance, negotiation, investor relations, and all of this is just off the top of my head while I'm sitting in the lobby. My career is incredibly expansive in civil law. Civil law is an incredibly expansive area of the law. I like to say that there are really three functions for a judge. There's what the judge does on the bench, and of course, you know, you want to run, and the need for this court is clear, that our civil case calendar is incredibly backlogged. We need somebody who can get in there right away and be able to start handling cases on day one. So there's effectively and efficiently managing your caseload from the bench, understanding issues, being able to make correct and accurate rulings in a timely manner. There's also your role sort of off the bench, but still related to your job as a judge in terms of being an administrator over your staff, being a liaison with the commissioner's court, being a member of the board of judges. In that regard, I've owned my own practice for off and on for 13 years when I don't take in-house engagements. When I am in-house, I'm a member of senior management. I meet with the board of directors. I'm typically the right-hand man to a CEO or a chairman, or both. I own my own gym. I've owned a gym for 5 years located in North Harris County in Spring. I understand what it's like to be in an ultimate decision-making capacity and have a leadership role, having employees, having a budget, having a staff. That's an incredibly big part of this job that a lot of people overlook. And if somebody is not used to that, that's gonna, you know, you're sort of running your own little fiefdom in the courtroom. You have, it's your own little small business. You have a budget, you have a staff to manage, you have people calling in sick, you have every issue that a small businessman has, you have those as a judge. And then finally, I think your third role as a judge is a role that I hope and would like to believe that judges take seriously, and that's carrying yourself in what I call a judgely manner. It's having a moral code, it's having an ethical code. So when you're not on the bench and you're not working, you're just out in public, you carry yourself with a level of decency and respect that a judge should command. I remember when I was a kid and I had a judge that was in my church, and I really looked up to this man. I want and think that judges should be people that we look up to. And I live my life in that way. I live my life according to a moral code. When I was in undergraduate school, I was a student of the Founding Fathers. You guys have seen that through in some of my questions, my answers to my questions. I had a focus in American political thought and political philosophy. As one of the things I did, I read Benjamin Franklin's autobiography, and I encourage everybody to read it. And Benjamin Franklin imposed a self-help and checklist where he picked what he thought were the 12 most important virtues, and every day before he went to bed, he evaluated himself on those 12 virtues. And over time, if he was honest with himself, as we should be, he determined where he was weak and where he was strong so he could focus on those. I lead my life in much the same manner. I am honest with myself, and I try to be the best person I can be every day. And I think judges should carry themselves accordingly. From there, I could keep going, of course, but we'll start taking your questions and hopefully answer them clearly.
All right, sounds good. Thank you again for coming in.
Yes, sir. Thank you.
Yeah, I guess one of Franklin's virtues maybe didn't have as weakness was his time in France, I believe, right?
I think so. His biggest vice,
As far as morals.
I think, for him was like temperance, being able to live in moderation. He was a man of excess.
Right.
And he really struggled with that. He recognized that in himself, but it's sort of hard to overcome.
So where'd you go undergraduate school?
The dirty C word. I went to a school called California State San Bernardino, which was a very unusual place to have such an incredible education. I started in Ohio. I went to Miami of Ohio. My mom lived in San Bernardino Valley in California in a town called Redlands. And Cal State actually offered a program in national security studies for a master's degree. It was one of two schools at the time in the country that offered that. It was either that or Georgetown on the East Coast. My mom being right there, I thought that would be, and I thought I wanted to go work for the NSA when I was a little bit younger. And so I went to Cal State with the idea that I would go into their NSS master's program. I quickly met a mentor of mine, a guy named Dr. Erler, and he was an American constitutional scholar, and he changed my life forever. And I started reading nothing but political philosophy. He guided me towards law school, and the rest was history. So I had this incredible conservative American political upbringing in this podunk school in the middle of nowhere, California, which is the strangest place of all. So,
In law school?
Law school is a small Christian school outside of Los Angeles called University of Laverne. I was all set. I was going to go to a bigger school, Pepperdine, and I was literally driving out to Malibu and trying to figure out how am I going to survive in Malibu, California. It's incredibly expensive. The law school itself is incredibly expensive. And as I was driving out there, University of Laverne, which was on my way, called me and offered me a scholarship. And I turned my car right around and stayed at home and went to school for free on scholarship instead of spending God knows what at Pepperdine. And again, I ended up having this brilliant legal education. The school was at a crossroads. They were trying really hard to get their ABA accreditation. I'm going to run out of time. And so they were very strict in their grading, and they were very strict with their education. So I got this incredible legal education, and again, a school nobody really knows anything about. We graduated, we started with like 35 students. We graduated 13 of them. Of the 13, 12 of them passed the California State Bar, which is supposedly the hardest bar in the country, on the first try. And the one that failed knew the law. He just had a language barrier. He was Asian and couldn't write the language well enough to survive the essay, but he knew the law, he just couldn't articulate it. So we should have had a 100% pass rate.
Wow.
We knew our stuff.
Impressive. Larry.
Got a question. You in the first paragraph on our questionnaire, basically you give your philosophy and everything, and you were all, many things that you were excelling in. You said, I was also a distinguished delegate at Model ARAB League Conference. Explain that. What is that?
Sure. So when I was at Cal State, there were, in the political science department, and at the time when I was in school, political science was undergoing a little bit of a shift of its own. Traditionally, political science has been more of the political philosophy and theory of politics, but at this point in time, with technology being what it was, it was really shifting more towards the science of politics in terms of polling and data analysis and data compilation and statistical analysis. And so there were really two branches of my political science department. There was a third because we had this NSS program, this National Security Studies program, which was International Relations Department. And I participated with the international relations people. We had an award-winning Model United Nations delegation, and we participated. My professor in that arena was a former CIA, there's no better way to say it, he was a spy, and he spent all of his time in the Middle East. So we participated in a lot of Middle Eastern politics when we would do these conferences. And so that was a Model Arab League conference on the West Coast, and it was up in San Francisco. And we represented in that Pakistan, and in my delegation, they award every delegation or every conference awards the best delegate, and I was awarded in the room the best delegate. So, and we won best overall for our team, which we did like 13 straight years. We had an impressive team.
You have 18 seconds.
You had 5 year, you're owned a gym for 5 years.
Yes, sir.
And the 13 years of your business ownership, that was your attorney business.
So yes, sir. I've owned the gym in parallel to my law practice. There was am I still up?
Don't worry about it.
There was a period of time where, so I had been engaged with a company that had me overseas quite often. I had an apartment in Holland. I was basically living there, and I was there about half of, I guess, 2013, and at the time my daughter was 2. And as I look back on that year of my life, I felt like I had missed that year of her life. And so I didn't want to do that anymore. And so I resigned from that job. Well, now I'm living in Willis, Texas. With the type of law that I practice, there's not a whole lot of deal flow that comes through Willis, Texas. So I was reevaluating sort of what I wanted to do with my life and career. And fortunately, I was in a financial position where I could make decisions not based on money. And fitness has always been another passion of mine, as well as the law. So it was a good time I opened the gym, thinking that I was going to dedicate more time to the gym, and then I got sucked back into more legal work. But the gym has survived. It almost essentially runs itself. I have 1 employee and 2 sort of volunteers that help me really manage that. So yeah, it continues on. And ultimately, my goal is to sell it to my employee here in the next couple of years when he gets out of school.
Okay, I have pretty good knowledge of a couple of situations, never having been a plaintiff or a defendant in a court case, but some knowledge of other cases where evidence or witnesses were not allowed to be presented. And I'm trying to understand what are the circumstances under which that's permitted. Is that purely the judge's discretion? Why would the judge do that? It would seem almost illegal or unethical to suppress evidence or witnesses.
Sure. So no, it's not necessarily discretion. There are rules of evidence, and they're voluminous. And you guys have probably heard of the hearsay rule, and people like to joke about the hearsay rule that its exceptions sort of swallow the rule. But there are certain circumstances where evidence, for instance, a chain of custody in a criminal matter, if you can't prove the chain of custody of certain evidence, then that evidence would be excluded because there's no sort of proof that this is the knife, right? So you've got to keep good records of the chain of custody. Similar to a witness, if you can prove that a witness for whatever reason has a substantial bias, then his testimony could be excluded because his veracity or his truthfulness could be called into question. But no, the judge doesn't typically have discretion in that. It's more of following the rules of evidence and the guidelines that the legislator has set out and applying sort of facts to the elements, which is really a big part of civil law anyway. every claim has certain elements that it has to meet, and so, fraud, for instance, has 5 elements to establish fraud. So you look at the facts and you apply the facts to the law, and then if they meet the elements, then fraud has been established. If they don't, it hasn't. Similar to the rules of evidence, that you apply the facts to the law and see where it comes out.
Okay, with my remaining time, let me pose this specific situation. I was sitting in the peanut gallery as an observer.
Yes, sir.
And the defendant was wanting to call a certain witness, and somebody from representing somewhere else said, Your Honor, I object, and the judge said sustained, and that's all that I could see from where I sat.
Huh. I wonder if perhaps this witness was maybe being qualified as an expert, and until that person has been duly qualified, their testimony is inadmissible. So if you call somebody to the stand to testify as an expert, and they have not yet been qualified as an expert, then they wouldn't be able to testify. You have to qualify them first. So it may have been a procedural issue that just sort of got lost in the mix.
From the peanut gallery, it looks very funny.
Yes, sir, I'm sure.
Okay, James.
Quick question, I may ask a different one depending. Now, in this court, the 257th, will they be dealing with debt collection, credit card, that type of thing?
Yes, sir.
Good, then my question deals with the fact that judgments come to Texas to never die. So these credit card companies and debt collectors would rather file suit than negotiate a payoff a lot of times, because that judgment can be valuable for ad nauseum. So my question is, when you look at the docket of the different courts, I can't remember which one I was sitting in, they had a huge list from American Express and several other, listed, that kind of thing. And of course, very few bothered to show up, defendants. Mm-hmm. And the ones that did were oftentimes pro se. So here's my question to you. As a judge in this court, what would be your duty towards a pro se defendant that differs from one that's represented by a lawyer?
So as far as the rules, the code of civil procedure, that applies to everybody equally, lawyers, pro se plaintiffs and defendants. But I've had this experience before too. I've been defense counsel in a case where a plaintiff was pro se, and I think a good judge will not necessarily give legal advice to a pro se plaintiff, but be a little bit more lenient with them when they miss something procedurally.
So you're saying, as a judge, you should be free and willing to aid them in process, but not in terms of legal advice.
I think even in
Right.
process, there's going to be limits to what you want to do, because you can't be biased in a case on one side or the other. And while you can be somewhat sympathetic to a pro se plaintiff or defendant, a pro se party, you still have to apply the rules equally.
Let me ask this then. Let's say that the pro se defendant had enough wherewithal to actually write an answer and address a lot of the issues that are in the original charge or,
Yes, sir.
Plaintiff complaint. Then the plaintiff comes along and files a motion to dismiss based on one of those issues that the pro se defendant addressed in their original answer, but they fail to file an answer to the motion to dismiss. Are you going to rule that the motion to dismiss carries for lack of defense, or what?
Well, the motion still has to establish and satisfy the elements in order to grant the motion. So yes, it's hard to rule in favor of an opposition that was never filed. But I also think that it may be difficult as a matter of law to establish your claim without having getting into evidence. I think motions to dismiss should be hard, and it's a high standard for a motion to dismiss. Here in Texas, we have a special adjudication, I think is what it's called, but it's essentially a motion to dismiss as a matter of law. And I've been successful in those in other jurisdictions. It's a little bit harder here in Texas, and I think rightfully so. I think you should get into evidence and get into discovery and really find out what's happening.
All right, thanks.
In the past, Montgomery County has had an issue with judges having their doors locked, not showing up for work, not putting in a 40-hour week, their staff isn't available. What is your feeling about you as a judge? Do you feel that you should be working a 40-hour, 60-hour, 10-hour week? And are your doors gonna be open every business day?
Doors will always be open. I've never worked a 40-hour week in my life. I work 80-hour weeks, 100-hour weeks. The job I had when I was overseas a lot, it was 7 days, literally 7 days a week, 20 hours a day. That's sort of unsustainable in a long environment, but I love what I do. I live what I do. Fortunately, I have a family who understands that I'm that way. I work from, I was telling John, I wake up at 4:30 in the morning and I start working. I don't go to bed until 11 o'clock at night, and I'm sometimes not even then, I'm constantly working. And in this particular type of court, and I think one of the things, I know I'm switching gears a little bit on you, but one of the things that makes me write for this particular court is you're going to have a lot of cases handed to you pretty quickly, probably 1,000 to 1,500 cases given to you on day one from the other courts. Part of being able to process those cases effectively is going to be a lot of out-of-court time preparing and planning and organizing and scheduling. And I mean, you see me, I'm showing up with notes, and I'm an organizer, I'm a planner, I'm a preparer. So I will spend as many hours as I need to get ready for what I have to do in the courtroom, so that when I get in the courtroom, it's gonna happen in a smooth and efficient manner. So yeah, I work nonstop. My staff's gonna hate me because they're gonna work hard. And that's just who I am, I'm a hard worker.
Okay,
Dennis?
there are some questions about CPS-related issues in this court. Will you get involved in any of those or not?
No, sir.
Okay, well, I'm gonna ask this anyway.
Okay.
There is a case going on right now about a 4-year-old boy named Drake Pardo. Have you ever heard of that case?
No, sir.
That's been in the news a lot. CPS had a dispute with the parent and went to court, and the court never talked to a doctor who had talked to the child, never talked to the child, never talked to the parents, and somehow allowed CPS to take the special needs boy, 4 years old, away. And the lawyer had all sorts of good points and filed things, and nothing ever happened. Our state rep, Steve Toth, and lots of legislature filed briefs with the court to get it changed.
Mm-hmm.
Finally went to the Supreme Court. The Supreme Court of Texas told the CPS that they had to do an evaluation to find a home with a relative. And they said it's gonna take us 6 months, and the judge said you got 2 weeks. So 2 weeks came and passed, and still nothing had been done. So I think he was allowed to visit with his parents this week. So the question is, on issues like this, where the government is so obviously out of control, I guess the judge will be up for election. We don't have lifetime judges in Texas, do we?
That's correct, no.
So, you wait 3 or 4 years, you maybe can find the judge. But the bureaucracy with CPS may still go on. So what kind of maneuvers are there that their attorney should have taken, or our legislators should have taken, or how do you stop something like that from just ruining somebody's life?
Well, I think generally, and I don't know the case specifically, so it's sort of impossible for me to comment on it specifically, but I think generally, we're talking about basically parental rights. Mm-hmm. And how far can the government go to interfere in a parent's right to raise their child as they see fit? And for starters, I think, and this is my own personal opinion, of course, that we need to start with some type of constitutional recognition of a parental right. And it can be limited, it can be not as expansive as perhaps you have the right to do whatever you want with your kid, but some type of constitutional recognition that you have rights as a parent. Now at the same time, you have to recognize that the child does have what Locke would have called natural rights, right? And natural rights are protected by the government, supposedly. And so the government's job is to look out for the well-being of the child in an event of mistreatment, abuse, neglect. So in those circumstances, I think that it's proper for a government to be able to step in and say, hey, parent, you're not doing your job. So we need to do your job for you because that child has inherent rights too as a human being. At the same time, you have to be careful about how far you extend that. And so recognizing some type of constitutional parental right, I think is the first step to that, because now you're setting the baseline of the parent is right and let's work backward from there, as opposed to the parent is wrong and let's work forward from there, if that makes any sense.
Well, I think, so the fundamental issue here was that the family doctor said this child needed a certain treatment, and CPS found a doctor that said, no, he needs his other treatment. And the judge based his taking the child away on that letter, and as I understand from what's written, that doctor said, no, that's not what I meant. And then the Supreme Court gave him a deadline and they ignored it. Why would the Supreme Court give him another deadline? Why don't they just lock somebody up?
Yeah, I don't know.
Okay.
I don't know.
So to piggyback onto that one, we have, a lot of us are against vaccinations. And we're having problems with CPS and overall government saying you don't have the right to not have your child vaccinated. Or we have issues where you don't have the right to take your kid out of a public school and homeschool them. How does that fit in if we do a constitutional definition on the parental rights?
Sure, I think you're gonna need to find some scientific consensus before it becomes a right of the government to step in. And until that happens, I think it's a right of a parent. Because I and I'm not overly familiar with the anti-vax arguments, but from the outside looking in, it seems like there are fairly compelling arguments on both sides, and there are scientists on both sides who seem to have scientific data to support their claims. So until there's proof positive that one or the other, I think the government's role is to not pick sides. And again, that would fall back to the parent's right as a parent, a fundamental right to parent. And that's the presumption, and now it's rebuttable, but your rebuttal evidence had better be pretty compelling. And right now, I just don't know that the science is there on either side to say.
Thanks. I know this is not in your court, or wouldn't.
Yeah,
be,
but I'm
it's still good though.
I like talking.
It's good information.
If you haven't noticed.
We're about halfway done.
Man, it felt like 5 minutes.
Yeah.
I like your clock.
Yes, sir. We'll do this all night long. You guys start talking about Constitution and that stuff. We'll do this all day.
There you go. One of their questions was, please describe what you believe are the most significant issues in this race, why and what you'll do to address them. One of the first things you addressed was that I guess the district courts, who's the coordinating authority over all the district courts that assess cases, or is it just board of judges?
So the Board of Judges and then the Commissioner's Court.
Yeah, okay. So they had been burned in the past by judges campaigning that they would be comfortable hearing a specific type of case, and I think it was civil, if I'm not mistaken, and now that's kind of going to the family court, the most recent court.
I think civil seems to always get the bad end of the stick in
shaft,
this county. Yeah.
The shaft, so to speak. Okay, and so there seems to be a concern by you that, at least with one of your opponents having a strong criminal background, that it might just kind of sway over to a criminal court instead of civil court to help work through those cases then. And while addressing that, I think you have a new opponent that just came in. He was at the MCTP meeting the other night, Chris.
Yes.
Did you see him?
Yeah, Chris Buck.
Yeah,
So
Chris Buck.
that was the first I've seen him. That's the first I met him.
Okay.
I don't know that he's filed a treasurer report. I don't know anything about him. So I can't speak to him.
Do you know, have you known him before the other 9?
No,
At
sir.
all?
No.
Oh, okay, okay.
We have one common friend on Facebook.
Oh, really?
I don't know him at all.
Oh, okay, all right. And so do you think that that could possibly happen, that this court, even though the Board of Judges and the Commissioners Court has said this is going to be a civil court, there's a possibility that that could veer?
I'm not gonna say that it can't, because it certainly could. And I don't know what the other candidates' intentions are. Certainly, I think, for me, there's absolutely no question what kind of cases this court's gonna hear, because that's what I'm qualified to hear. I did one divorce case in my entire career. I don't wanna do another one. It was an 87-year-old man divorcing his 82-year-old wife.
Oh my gosh.
I represented the wife, and she was absolutely in tears every time I talked to her. And what had happened was he had grown children from another marriage, and they didn't want the wife to get the inheritance. Now, granted, these are like 65-year-old children, and they didn't want her to get their inheritance, so they talked the old man into divorce. It was absolutely miserable. I'd never do another one. So I'm not going to turn it into a family court. My only experience in a criminal court was when I was in law school. I clerked for a criminal defense attorney, and I did my job really well, and we got a criminal off on a technicality, and for about 2 seconds I felt really good for doing my job really good, and then I realized I just got a criminal off. I didn't feel very good about it after that, so I knew I didn't want to do criminal law from there. So there's absolutely no chance of me changing this court into anything other than what it's prescribed to do. It seems, and I use this analogy, I have nothing against my opponent. I think he's a very nice young man. I'm sure him and I will get along famously when this is all over. We get along fine now. I think he is a square peg trying to fit into a round hole. And that's not to say that a square peg is bad, it's just that the square peg fits better into a square hole. I'm a round peg, and I fit very nicely into a round hole. And I think that's the best way I can describe it. So he spends time trying to make the job fit his experience, and it's easy for me to just say how my experience fits the job. And so that's why I think I'm the better fit for it.
Okay. All right, Larry.
One of our questions was, please describe the best way for the average voter to determine which judicial candidate is best. Give us an overview for our viewers that are going to be watching this.
I want to make sure I'm consistent with what my answer was.
It would be nice.
So I think the number one thing for any voter in any race is to be informed. In today's world, with social media, with websites, with newspapers, with all of this data available, it should be fairly easy to be informed. If you want to be informed, you should be able to, you can be informed. I have a website, I have an email address, I have a phone number. If you want to know anything about me, call me anytime. I'm obviously happy to tell you about myself.
4:30
You know
a.m.
what we're doing here.
Exactly what we're doing here. So the number one thing that a normal person can do is keep yourself informed. And this is applicable to any type of race. I think in a judicial race, it's important to, again, get the right person for that court. And in this case, it's incredibly important because, again, you're going to get a whole lot of cases, again, probably 1,000 to 1,500 cases on day one handed to you that aren't new cases. These are existing cases sitting in other courts. So they're not going to turn the spigot on nice and slow and let you learn how to do this. They're going to open the floodgates, and you better be able to swim. And if you're not, all that results from that is you will have to flip the court into another style of court where the person is actually qualified, and or spend a whole bunch of money on visiting and guest judges to come and handle the caseload, or heaven forbid, have to create yet another court to handle the job because you didn't get it right the first time. So this particular race, in this particular court, I think it's incredibly important that a voter vote based on somebody's qualifications and experience. Now that said, and there's a lady who says she's voting for my opponent because his mom lives in her neighborhood. That's gonna happen, right? That's gonna happen. There's gonna be somebody who votes for him because he has nicer hair than me. or he's taller than me. You know, you can't avoid that, but you hope that the vast majority of people are going to keep themselves informed. And in this particular race, experience and qualifications are the #1 factor.
Can I add on that one? So you know that we have a website called US Vote Smart.
Yes, sir.
Do you feel that, have you looked at that website?
I have.
Do you feel that that's good for the public, a good source for people to go to find out about you and other people that are running for a judge position or other positions?
Sure. I think I'm a fan of data points, and the more data points that are out there, the better. So, you know, I've been on your guys' YouTube video extensively, watching other interviews, hearing some of the questions, seeing how other people, again, I like to prepare myself. I don't walk into a room unprepared. I try to be as prepared as I possibly can be. So I was able to find data points and to prepare myself to come in here. Why couldn't somebody else do the same? It's simple. It's all there. It's just a matter of, you know, are they willing to, do they care enough to do so? Or are they going to vote for somebody because their mom lives up the street?
Okay, you answered that the Board of Judges unanimously and unequivocally approved a resolution indicating the court will bear all civil cases. Can you point us to that documentation?
Sure, I can provide it to you. I have a
Okay,
copy.
if you do that.
It's a public record request I made.
Okay.
I can, yeah, I'll get you guys a copy of that.
And second of all, you said in any event, and this was in the context of what carries the greatest influence on your rulings, law, constitutions, or other, your closing paragraph says, in any event, I believe sound interpretation of laws serves to aid in the understanding and application of that law, should be followed for consistency and to uphold the rule of law. In circumstances where the interpretation is demonstrably erroneous, however, I also agree the court should and must right the wrong. Can you cite an example where you believe that the court should or must right a wrong interpretation?
Generally speaking, I mean, there's Korematsu where I think it's a famous one where we imprison Japanese people on the West Coast. I think that was probably a bad decision. In retrospect, you know, you have the civil rights cases, which of course I think were a reinterpretation of law. I think, I mean, now just speaking generally, and I think Clarence Thomas is good at this. If the law is bad, you don't just follow it blindly and say, well, it's just the way it is, it's the way it's always been. I do think that the courts need to use a scalpel and not a hatchet. And so, you know, you don't want judges making law from the bench, but there's a way, and I think in many instances the court probably does this right when they overturn or overrule existing case law. It's done with a scalpel. It's done razor thin in a particular set of circumstances, and it's not typically a just broad overhaul of an existing law. So in clear instances where law is bad, I think the court has an obligation to right the wrong, but I don't think the court should be out looking for circumstances in which to do that. I don't know if that helps or if that directly addresses what you're trying to get to.
Okay. Well, you gave a couple of examples up front, and I was looking for a specific example of one where you felt like it was, and so you did answer that.
Okay.
Yeah. Okay, time up. Okay, James.
Yeah, let's talk about, just very quickly, about religious law in court. Now, we
Which
know.
law? I'm sorry?
Religious
Okay.
law. We know that Catholic covenants in dealing with custodial issues in family court have been upheld, I know in Texas and other states, dealing with issues of custody of the child with regard to religious training and that sort of thing, something the people agreed upon at the child's birth. Let's talk about financial transactions, because we know that even in this country you have Sharia banks that have been established, and they follow their own particular code. So my question is, let's say you have a case in your court where there was an agreement between a married couple, and this, well, I don't want it to be a family case, an agreement between a man and a woman that aren't related. And in Sharia law, basically, where that occurs, the options of the female are subservient to the options of the male, depending on the law. But let's just say the contract you're given simply says that this financial transaction will be conducted under provisions of Sharia law, and no Sharia law was attached as an addendum. How would you handle that situation?
I think you need to, again, we have to talk in generalities, not
Sure.
specifics, because, you know, it's not a particular, you gotta see
Right.
facts, and every case could be potentially different. But in a general sense, I think no matter what law you're attempting to apply, it has to still be consistent with your law of the land. And so, I don't know Sharia law. I would,
Well, on that point now, we're talking about a contract.
sure.
There is no real law that says the contract has to be fair and equal.
Right.
I can agree to an unfair arrangement,
Sure.
but I'm just saying that if the Sharia law is referenced but not defined in that contract, you just declare the contract invalid. You ask the party to present the Sharia law, or how do you deal with
Yeah,
that
you're gonna have to
situation?
get an understanding of the law. I mean, let's take Sharia law out of it and say that the law of Denmark is going to apply. And
Yeah.
that's within a party's right to apply the law of Denmark, and it becomes my job to get an understanding, a working
And
understanding
would your
of the
court be
law
the
of
proper
Denmark.
forum though for Denmark law?
No.
So you basically would have to dismiss it.
Well, it would be filed in a federal court more than likely in the first place.
Right, true. Now, in this case, Sharia law, it's a state contract, or a contract under state law, it would go to federal court per se.
Yeah.
So would you just say,
I think you're still gonna have to get you're gonna have to get an understanding of the law. Just again, whatever law is referenced in the contract, if
Yeah.
that law is going to apply, then you have to understand that law. And so yes, I would ask the parties to brief me on the applicable provisions of Sharia law. And potentially we have to bring in experts who can tell me about Sharia law. You know, if this is gonna be a bench trial.
right?
Yes, I have to get an understanding of the law I'm trying to apply.
Okay, real quickly, on an unrelated issue, let's say, because this is something I've
Time's up.
observed in court here in our county.
You guys
It-
are
it
asking
appears-
tough ones tonight.
It appears to me that a lot of judges haven't even looked at the file until it's right there in front of them and the parties are there. If there is a motion filed and a motion answered, and it's a matter of law, not a matter of evidence, are you still going to require that they appear before the bench if you have time to look at it and address it? Or are you going to go ahead and make a ruling, unless the parties ask for it? No parties asked for a hearing, but they've asked for a ruling. Are you still going to require everybody to appear and incur the expense for their clients, or are you going to rule from the bench?
This is a really good question, I like. So, one of the things I want to look at, and I'm not going to make any definitive statements, I'm not elected yet, and I can't say what is going to work and what's not going to work, but I've seen this in different jurisdictions. Look, we're not the first county in America to have a backlog of civil cases.
Sure.
We're not. So we can look at what other courts have done to help alleviate this backlog. And one of the things that I've seen several years ago is instituting on law in motion, something like you're talking about, a process of tentative rulings. And so courts will, you know, you file your motion, the opposition is filed, and then the moving party has an opportunity to reply. And that's usually 5 days before the hearing. So the night before the hearing, the court will put out a tentative ruling. And it is a 2-paragraph usually explanation of why I'm ruling the way I am.
Right.
They put that out on the website. The parties then have the option of accepting the tentative ruling or appearing for oral argument. 9 times out of 10, they accept the tentative ruling because they're realistically not going to show up and convince the judge. Well, part of the thing that happens in a civil court, and I've had this happen to me, I've made a really good argument that just came to me while we were arguing the motion, and the judge said, well, counsel, that's a great argument. I wish it was in your papers. But because it's not in your papers, I'm not going to consider it because the other side hasn't had a chance to look at it. They haven't had a chance to review it and respond to it. So, great argument. Wish you would have said it earlier. So the same thing will apply in my court. Oral argument in a civil law in motion is in a lot of ways redundant because if I've done my job, I've already reviewed the papers, I've already basically come to my ruling. I would love, if I can, to institute this process of tentative rulings. You can accept the ruling, not show up the next day.
And you mentioned the website, just so you know, Odyssey, it's used for case filings here, really sucks.
I've heard,
Is that a question?
and that's gonna be an issue.
Yeah, the question is, if you feel like you need help, you're gonna ask for assistance, because here you go.
Because I'd very much like to, again, in today's day and age, I think using technology to your advantage helps save the litigants money,
Yeah.
helps save the litigants time, helps save the court time, and helps you process cases faster.
Right,
So
definitely.
everything I can do to help expedite that, I'm gonna look at.
Okay,
I have a
thanks.
quick question. He took
Yeah.
most of
Appreciate
your
it,
time
Robert.
down here.
Okay, about enumerated power, you know, every day conservatives wake up and say, where does the Supreme Court get authority to rule on abortion? Where do they get the authority
Marriage,
to rule on marriage, or all these host of things that's not listed in those.
Yeah, healthcare.
enumerated powers. So you can share your thoughts on that if you want to. But is there a comparable list of enumerated powers that would apply to this court? Do you think there's gonna be cases where you say, no, this is not for me, this is for the city, or this is for the feds?
So, yes, you're talking about just basic jurisdiction. So the district court has original jurisdiction in cases that are over $200,000. So anything over $200,000 lands with me or Judge Bays or presently Judge Robin. If it's 200,000 or less, it can be any of the three of us. We have jurisdiction with the county courts of law, so it could be any three of the three of us or Judge Laird. I think my minimum is $500. $500. So basically everything from 500 to, well, 200 to 500 goes to Judge Laird. 500 to 200,000 could go to her or us. 200,000 goes to us. 200,000 or above goes to us.
And JPs are.
And JPs are down with the under 500 as well, sorry.
JPs are up to 10,000 now.
Yeah, 20,000, they've just passed it up to, so that's more of a small claims case.
What is the difference between JP court and small claims court?
Not much,
Yeah.
not much.
So they always list them, you go to the website, they list JP here, small claims here. Okay, that's all my question.
Okay.
well, hopefully the claims court actually has somebody with a Juris Doctor sitting behind the bench.
So the difference,
Same
the
JP.
JPs don't have to be
No.
lawyers.
No,
Yeah, they don't.
thankfully.
And the county judge doesn't have to be a lawyer either.
That's
We
what
know
you
that.
did.
Or sober.
Do you have a question? Huh?
Keep them coming, y'all.
Okay, I got one, because I got skipped over.
Dills?
No, wait,
Well, that's because you took an insert before.
Well,
You inserted.
So I'm gonna take an insert
Not
now.
even a full minute.
Dill, let's go.
Okay. Found one of your other answers somewhat interesting, talking
That's not
about
an
the
insert.
US and Texas constitutions are the living documents, and you gave a very interesting response to that, but one of your quotes in here, Thomas Jefferson believed the Constitution should be replaced every 19
Yeah,
years.
can you believe that?
And you gave a pretty strong argument, and I was thinking, well, what are your thoughts? I mean, because that's obviously, you're a very strong originalist.
Sure.
And so do you support the every 19-year thing, or do you think we ought to stick with 1787, or talk a little bit about that?
I am not apologetically not a big Thomas Jefferson fan. And I think history has, in a lot of ways, proven him to be wrong. Now, granted, he was the author of the Declaration of Independence, and it's a brilliant document. He's a founding father. He's a brilliant man. I have a ton of respect for him. I'm more of a Hamiltonian. And I think history has proven Hamilton's, well, our country today is much more the view of Hamilton than it was of Jefferson. Yes, Jefferson wanted the Constitution to be essentially thrown out every 19 years because he believed that society changed, morals changed, norms changed, and the law should change with those changes. He was obviously not, like that argument wasn't accepted because we didn't do that. We didn't throw the Constitution out every 19 years. So the reason I brought it up was to prove the negative, essentially, that because we didn't accept that argument, we rejected it. And so the idea that the Constitution is this living document that changes with the times, that was Jefferson's view, and we rejected that. We went with the view that this document lasts for all time. And to argue today that the other way, the more progressive view, is, I think, just wrong, going all the way back to, they had the exact same argument. And they picked a way, and our country has followed that way, and I think it's been rightly followed that way.
Well, don't you think he felt there were compromises made in writing and passing the Constitution that he felt should be changed? I mean, he had states that had mandatory religious affiliations and slavery and all that sort of thing.
Well, and so the big schism between the anti-federalists with the Jeffersonians and the Hamiltonians, the Federalists, was over the power of the federal government. And Jefferson was from Virginia, a large agricultural state, the largest state in the Union. They wanted states' rights. And there's a misnomer today when we hear that Hamilton was a proponent of strong government. People equate that to mean big government. And that's not true at all. Big government is a product of bureaucracy.
Right.
That's the problem that conservatives have with big government.
Definitely.
Nobody has a problem with strong government.
Yeah.
Strong federal government, when we're talking about enumerated powers, is exactly what the Constitution predicted and expected. This bureaucratic state is not. So people misunderstand those terms. They equate big with strong, when in fact, strong did not mean big, it meant strong. And we built in, remember, the 10th Amendment, which reserves all powers not given to the federal government to the states. So they also envisioned strong state rights, but always subservient to the federal government. And you have to go back to that time where they were enacting a new federal government. It had to be strong, otherwise it was going to fail.
What do you feel the 14th Amendment pretty much eviscerated the 10th Amendment?
No, I think it probably supports it.
Well, it's used as the leverage for like the Commerce Clause.
Sure.
Yeah,
Yeah,
to
the necessary
override.
and proper, sure.
Exactly, yeah.
The abused commerce clause.
But I think, on this topic, I think the Rehnquist court did a fairly good job of bringing the 10th Amendment back to life. And so far, I think the current court is actually pretty good about applying states' rights.
Yeah.
So over the last 20, 30 years, we've actually maybe righted the ship a little bit.
I agree. Which I know you feel is important.
Going once, going twice.
Well, I've got another one, but Bob had one.
Bob?
I was just gonna bring up civil asset forfeitures.
Sure.
Yeah, that was the next one in
Nice.
line.
It's a tough
Yeah.
one. It's a tough one because you look at, if you look at the ends justifying the means, it kind of feels right. Like cops are getting bulletproof vests. Who doesn't want a cop to have a bulletproof vest? Of
Right.
course we want that. But the ends does not justify the means. And the right to property is, again, we're going back to Locke, is a fundamental right. This is a right that shouldn't be tampered with lightly. And the process as it exists, I think, is overly broad and needs to be dialed back. I think it's, and I think the way Judge Bays put it in her interview with you guys was right. She said, it's a good idea gone bad. And so I think there's different ways that you could hone it in. Until the legislator does that, we're kind of bound by what we've got. Because again, the counter side of that is you don't want judges legislating from the bench.
Right.
So you really have to apply the law, and the law is pretty clear. It's again a set of sort of elements, and you just go down the list. Is this proved? Okay, I have no choice but to follow the law. When courts start taking justice when judges start taking justice into their own hands, it's a dangerous thing. There's the case in Massachusetts where a state court judge knew that, and this was in the news, but not a lot of people talked about it. It kind of went through pretty quickly. But she had a defendant in her courtroom, and she came to find out that ICE was in the lobby of the courtroom waiting for this defendant. She turned the mics in the court off for 7 minutes, had a conversation with the defendant, and then had the bailiff escort him out the back door. She's been arrested, and the bailiff's been arrested for obstruction of federal justice. Rightly so.
Right.
You should not be taking the law into your own hands.
Right.
So,
What about nullification? Say in that case.
jury nullification, also a tricky one, because on the one hand, this is a feature of our system that was built in by the founding fathers. This goes all the way back to England, right? This concept that if the jury believes that the law is bad, then they have the right to ignore it. It's a dangerous game. And so I think that the issue isn't whether or not it can be applied, because I think history has shown that it can, and our system is designed so that it can. I think the issue now is whether a judge should be obligated to give a jury instruction on nullification. And I tend to side with no. That if the jury comes back and says, hey, we're thinking that we don't like this law, is there something we can do? Then the judge should instruct the jury on nullification. But it shouldn't be something that you just provide them beforehand, because they have the ability to misuse and abuse that process.
What if the defense attorney makes that argument? Would you stop it?
I don't think that they're allowed to presently. We have to look at
Yeah.
that. And it's less of an issue in a civil context. To me, it's not really an issue in a civil context because
Yeah.
you have a right to an appeal. But in the criminal context, you know, if they're acquitted, you only get one bite at that apple, and you've just lost it. So it's a dangerous thing in a criminal court. Not very dangerous. Plus, you don't have a very compelling state interest in a civil matter between two private parties that you have in you know, a criminal case. So it is a dangerous thing. It's a hard one. And it's probably above my pay grade.
All right. Well, we appreciate you coming in. Thanks
it.
very much for your time. Yeah.
We had so many more
We
things.
could go another hour if you like.
Well, I don't think
But
you
I
guys
don't know
go
if
for
these
it.
guys, yeah, I
You
could
gotta go and
push back. Huh?
Are we done?
Closing?
Yeah.
Oh, I'm fine. If you guys want to ask
Said-
more questions,
Yeah.
I'm good.
All right.
Thank you very much, sir.
Thank you.
Thank you all.